Hello everyone, welcome to Cashcroft TV. My name is Kalen Ashcroft. Thanks for watching this first video on Guide to Legal History and Historians. This series must not be watched in chronological order, so feel free to pick whichever you choose. The only caveat being it might be fun to watch them in order just to see as I progress throughout the process. However, even for the same reason, you can go backwards. So nonetheless, the source for this series will be the Oxford Handbook of Legal History by Markus D. Dubber and Christopher Tomlins. I have been told by the Oxford University Press that I can make this. However, I must give the caveat that I have not been vetted or endorsed by either the editors or the Oxford University Press. But nonetheless, so far, this is no copyright issue. So, without further ado, because this is the first video, I will cover the preface. However, this video will be focused on two intellectuals, Maximilian Del Mar and Ron Harris. But nonetheless, here is the preface. So, couple words on the editors. There's Markus D. Dubber. He is a Juris Doctor from Stanford. He did his Bachelor of Arts at Harvard, and he's currently a professor of law and criminology at the University of Toronto, Faculty of Law. The other editor, Christopher Tomlins, is a doctorate in history from Johns Hopkins University, a Master of Arts in history from the same university, a Master of Arts and a Bachelor of Arts in politics, philosophy, and economics, PP&E, at Oxford, as well as a Master of Arts in American Studies from the University of Sussex. He is also the Elizabeth Jocelyn Bolt Professor of Law at Berkeley School of Law, also called Bolt Hall, so fitting for his professor's name. The book was originally titled The Handbook of Legal Research. However, during the gestation period, they changed the name to the Oxford Handbook of Legal History, which to me is a more general sounding name and I think more fitting to the piece. This is not an encyclopedia guide of topics in legal history, and the goal was never a handbook across time and space as well. So is another reason that you don't have to watch this in order. The videos will not be chronological as well. And we will not be addressing specific topics either, but more so different intellectuals and their ideas and their works. It is a culmination of different approaches and philosophies, and in my part, as you might have seen in my previous series, I do focus more on the actual individuals rather than the ideas as well. So it's, I think, fitting also that this is the purpose of the book as well. They, as you might imagine, thank all the contributors who, and I as well thank them in effect. And they said this is not exactly what they had in mind for the project, but they said a handbook that does not deviate from the plan is a handbook not worth making. So I think the same thing for this guide. This series will, as with my other series, will probably not turn out exactly as I planned, but if it turned out exactly as I planned, it would not be worth making, as the editors imply. And the focus is on inspiration rather than potentially soon-to-be outdated facts and information. So that's the spirit in which I hope to approach this series as well. I'll go through it with inspiration rather than focusing too much on the details. And I endeavor and expect the same for myself. And once again, I thank everyone in advance who contributed to the book and who has also supported my intellectual endeavors throughout my life and going forward. So, without further ado, as with all my other series, it's fitting because all these sections are based on different works by different intellectuals. So I will once again be covering the two chapters, but then I will also run into a comparison as well of the two intellectuals as well, inspired by Plutarch's Lives and fitting to my other series as well. So, without further ado, we'll start with Maximilian Del Mar. So this is in the section of contexts, locating legal history, and the chapter itself is titled Philosophical Analysis and Historical Inquiry, Theorizing Normativity, Law, and Legal Thought. So a bit about Maximilian Del Mar. He is a professor of legal theory and legal humanity and the director of graduate studies at Queen Mary University of London. He had studied law, literature, and philosophy as a bachelor's student, and then he later received a Bachelor of Law from the University of Queensland in Australia. He has a doctorate in law from the University of Edinburgh in Scotland, and in philosophy of the sciences from the University of Lausanne, Switzerland. He has also worked as a solicitor previously before his academic career in Australia, and he was also a judge's associate to the Honourable Justice Margaret White for the Supreme Court of Queensland. So the purpose of this chapter and a large part of his current work is what is the relationship between philosophical analysis and historical inquiry? What is a partnership or tension between the two beneficial for the practice of theory? What specific virtues does historical inquiry bring, and what is lost when theorizing is restricted to philosophical analysis? And furthermore, why does this matter for theorizing law and legal thought? So he says that these are very old questions, and it traces back this contested two different philosophies, back from Jeremy Bentham and John Austin on behalf of the analysis side, and to Sir Henry Maine on behalf of history and anthropology and comparative studies, to H.L.A. Hart's perennial questions and armchair concepts of the law. Furthermore, there's Brian Simpson's and William Twinning's emphasis on law in contract. So he's done much research into many of these individuals, and essentially what he's saying is he's manifested the conflict between the philosophical side contrasting with the direct historical analysis. And bringing into recent times, there's John Gardner, who's standing up for autonomy and priority analysis. There's Gerald Postema, Michael Lobin, Roger Catterall, and Jeremy Walton, who have pushed in favor of history of ideas. There's also Nicola Lacey and Christopher Tomlins, who's one of the editors of this Oxford Handbook of Legal History, Robert Gordon, Brian Tamaha, Patrick Glenn, and Fernanda Piri, who have favored a more general historical approach, often including sociology, anthropology, and the humanities as elements. So some of the ideas of these debates occur in the background of quarrels between philosophy and history. So the crux of the debate is that there's the one side where there's the philosophy, which is strictly analysis, versus history, where it's generally seen as strictly context. So where is the overlap, and to what extent should they be combined? And furthermore, how do these affect the legal domain? Further examples are Isaiah Berlin, Alasdair McIntyre, E.P. Thompson, Bernard Williams, and Quentin Skinner, and these are only 20th century manifestations. The point is that Maximilian Del Mar points that these individuals have to care not to lose sight of the crucial value of historical inquiry, focusing on both theory and practice. But I will explain this in further detail. These are the intellectuals who have sort of kind of pushed and pulled on both sides of the debate. So one of the further questions he poses is, why is legal history sidelined in education syllabuses? And one of the reasons he cites is that arguments are negative in character, in that by studying history, you kind of discount philosophy by showing a time boundedness of philosophy as well. He says, though uses the words spoil sport, and a dispensability of the philosophy, or deflate and diffuse philosophical enthusiasm and some hard-nosed philosophers try to avoid this and don't want to be deteriorated to granules of sand. So we must focus on positive virtues, not distinct from philosophical components. So what he's saying here essentially is that by focusing on history, you are detracting from the philosophical component of the law, as we will see. but Maximilian Del Mar advocates that both can be combined, both the context as well as the philosophical approach. The cost of demonstrating the uniqueness of history is, in contrast, the universal and Platonic forms and the changeless substances. So it's, as we will see, they are not completely unreconcilable, but there is a clash between the two. So he brings us to the example of, whereas on one side we have philosophical analysis, which is really the breaking apart and dissociations and systematization of different ideas, versus historical inquiry, which is the art of variation and change and persistence over time and associating relations. So he uses H.L.A. Hart's rules as applies to normativity. So we have normativity could be seen as just rules. However, if we distinguish both rules and habits, we can differentiate it from naturalism. So naturalism would be strictly rules, but normativity has both rules and habits, therefore has a place for both philosophy and history. So if history can be extended or extrapolated to different lengths of time, depending on the scope, it is theoretically generative. And the question is, why X length of time? So essentially, because history can be viewed in different scopes, different lengths of time, not just necessarily time, but also different, as we'll see, different different speeds, for example, or different cultures, for example. There's different scopes you can look at history. Therefore, it's by the fact that these exist is a positive element and therefore qualifies as a philosophical element of history. So how does normativity interact with befores and afters is therefore generative. So the epidemic virtues, or the contingencies, the primary principles are contingencies and of multiple temporalities. So I'll detail this further. So if we historicize historicize, he says, is to vary, or to study the variation, which is therefore a positive element. And the terms fate, and then he uses the example that we could even historicize history itself. So for example, how has the determination and changed over time? Like, for example, how frequent has the word fate and destiny varied over time, would be to historicize the study of history itself. In terms of temporality, there's the contingencies, which is not just cause and effect, but like what is if X and Y are removed is the point of it puts the generative element in. And then there's the temporality element, which is the different ways of modeling time. So he cites a couple examples. So in addition to just strict time, there's spatial, linear, cyclical, and parallel time. There's speed, degree, direction, and duration. And there's others even further, such as bucolic or emotional time as well. You can historicize different types of modeling over time. For example, Fernandez Brodel created what's called the longue durée, which is a focus on the Nazis' occupation of France exclusively. So in this example, one intellectual had a large implication on which scope of time they studied in history. In terms of theorizing law and historical inquiry, there's therefore a suggestive element, and we should start, he suggests, by saying what means to treat law as existing across time and places, to acknowledge its contingencies and explores its multiple temporalities. So then he goes in this particular section into a discussion of H.L.A. Hart's The Concept of Law, which was written in 1991, which was a study of anthropology, drawing from Malinowski, Diamond, Llewellyn, and Hobel, and Evans, and Llewellyn and Hobler collectively, and then Evans, and as well as Pritchard and Glocksman, as well as Roman Legal History by Scholes. So essentially what he said was the foundation of law came from curing defects and secondary rules, and that there were, and he's been criticized that his philosophy of history, or his history of the law, lacked contingencies and was over-deterministic. Neil McCormick criticized it, saying it was thematic rather than even a historical study, and he said it was an ex post facto argument, and he uses, for example, he neglects the contingencies. What if X and Y were taken away? Then Peter Hacker also said that it was, in his defense, a time-honored method, and it had crucial factors but not empirical evidence, but therefore is Hart's work irrelevant if it does not have any crucial factors that would exist in a different system. John Gardner criticizes it, saying he does not care or have reason to care how actual legal systems emerge in general, and it's an irrelevant fable. Brian Simpson says it's an evolution driven more by institutions rather than rules, so just going a completely different direction from Hart. So, furthermore, Hart's secondary rules are messy and conflict and struggle, but they measure a conflict and struggle for power led to the discovery of law. But nonetheless, the point here is that was heavily criticized by many intellectuals. For example, the Maximilian Del Mar states that the word statute did not even exist in England until the 13th century. So, by viewing it by Hart's approach, it would be it's not taking the right look at it. Neil Duxbury said there's no real distinctions were made between enactment and adjudication. Peter Kane said in his Controlling Administrative Power, says a comparative history in 2016 said England was a purely monarchical curia, so therefore there were no secondary rules, and it was completely run by the government anyways, so therefore Hart's work is not relevant. But Hart said that law emerges from the union of primary rules, which were being followed by the population, and secondary rules being followed by officials. The introduction to pre-legal to legal. So Louis Mink further. So what Maximilian Del Mar advocates, however, for is by using history as a metaphor, and more can be done from discontinuities between oral and written culture. But furthermore, we shouldn't just look at the closed system as Hart did, but also look at the befores and the afters. For example, even Hart notes in his own work that there was a long history of oral legal forms that existed before they were written that also, as Maximilian Del Mar states, have to be studied. So although Hart did get beat up quite a bit in this section, he did pose, it was evident that he did address some of his, the faults that were attributed to him. Louis Mink, so there's epistemic benefit of historical inquiry, where the historian must act in an act of judgment, hold together the thoughts and events which by destructiveness of time no one could experience together. So looking at the objective system. The metal pasts in ways that do not necessarily overlap with experience. So what Maximilian Del Mar says is that history, this is a very technical section, and one must really delve into Hart's work to actually form a real criticism of its merits and its faults. But essentially, one cannot look at it just through one lens, and even if one tried any of the lenses, I think they could all beat each other up quite a lot. But nonetheless, one must, for example, look at the contingencies, like what happened before and what happened after, and also the temporal factors, different lengths of time, different space, different speeds of time, and also what comes before and after. There's the oral history as well, and also looking into metaphor as well, which is a feature of legal thought, he says. So, yeah, this is we'll talk. This will make a lot more sense in the comparison as well, and it's very technical thought. The next section is more of a discussion of the development of a specific historical development, more like the work of Hart's. But nonetheless, I hope this might have exposed you to some of the thoughts of Maximilian Del Mar. So, in terms of the slide you have here, his nationality is Australian. His current position is Professor of Legal Theory and Legal Humanities and Director of Graduate Studies in the Queen Mary University of London Department of Law. His suggested readings, some of his books are Artifacts of Legal Inquiry, The Value of Imagination in Adjudication, Legal Theory and the Social Sciences, volumes 1 to 3, Legal Theory and Legal Academy, volumes 1 to 3. And in terms of the images, we have up in the top right the logo of the University of Queensland, second from the top right, the University of Edinburgh's logo, then Lausanne University's logo, the Supreme Court of Queensland's logo, and Queen Mary University of London logo. And as you can see here are the 4 questions that he attempted, and I think he achieved in addressing, or at least posed further questions for inquiry. What is the relationship between philosophical analysis and historical inquiry, which, as he says, is obviously they are tied, and they're not irreconcilable. What is the partnership or tension between the two beneficial for the practice of theory? What specific virtues does historical inquiry bring, and thus what is lost when theorizing is restricted to philosophical analysis? And why does all this matter specifically for theorizing law and legal thought? So, and the point is they all need to be addressed, and the two need to be addressed as well. So, without further ado, we will continue to Ron Harris. So this section is chapter 2, also in the section of context, locating legal history. His chapter is called The History and Historical Stance of Law and Economics. So Ron Harris is the Kalman Lebowski Professor of Law and History and former Dean at the Tel Aviv University, Buchman Faculty of Law. He has a Bachelor of Arts and a Master of Arts in History and a Bachelor of Laws from the University of Tel Aviv University. He has a Master of Philosophy and Doctor of Philosophy and History from Columbia University as well. His main focus is in the history of the business corporation, mainly from Britain and comparatively to other geographies. So, law and economics is, as he states, the most influential scholarly movement in the U.S. law schools in the last half century, and the most controversial of recent decades. So his questions he poses are: how did it become so rapidly influential? What made it so controversial from the start? Why didn't it interact with legal history? And what are the prospects for future interactions? So he goes through a section on what happened pre-1970s, the intellectual bedrocks of the law and economics movement, to the analysis of the formative movement in Chicago from 1970 to 1985, which shaped the interaction between law and economics, and then he further continues to beyond Chicago to more pluralistic and global challenges to coherence and viability in law schools. So, back to static and ahistorical, and then he continues back to Chicago for static and ahistorical nature of the interaction of Chicago. As we'll see, the economics and history are not combining properly in the field of law. And lastly, he finishes with a prospectus for more historical orientation, given the internal and external challenges between the two fields. So, starting with the pre-1978 precursors, so some of the most influential thinkers of the modern era, including Adam Smith, Jeremy Bentham, Karl Marx, and Max Weber, studied both law and economics in their studies. but none had a direct influence on the law economics movements. Rather, some debate that the origin was before World War II and some after. However, as we will see, he believes it's after. Some connect the law and economics movement with early 20th century institutional economics, or the 1920s and 1930s as the first great law and economics movement. Prominent first-generation law and economics scholars renounce pre-war origins in favor of late 1940s and 1950s and key figures of neoclassical schools of economics, which are, they say, were not manifestly inspired by the old institutional schools. So he believes that the real movement started from the Chicago School of Economics, which was led by Frank Knight, who later attracted Milton Friedman in 1947, Friedrich Hayek in 1958, and Friedrich Hayek in 1950, and George Stiegler in 1958 to join the economics department. At this time, they were purely neoclassical, highly mathematical, anti-interventionist, and more conservative than previous schools. Henry Simons in 1934 began a personal connection between the law school and the School of Economics by offering a 4-year program for individuals without undergraduate degrees to study both law and economics at the University of Chicago. And it was later continued by Aaron Director. So just know when I keep saying director, I'm referring to Aaron Director, not the director or a director. He taught price theory and parallel to his brother-in-law, Friedman, and Walter Bloom's courses taught in the law school. They also at this program taught antitrust courses and non-interventionist stance with Director and Edward Levi, the dean of the law school. So this was when the first, because at this time in the 1950s, there had been no real link between the economics departments and law schools until the University of Chicago. In 1958, the director founded the first Journal of Law and Economics as well. Not the director, pardon me. Director founded the first Journal of Law and Economics. So it's important to note what Harris is pointing out here is that it was this sort of conservative mathematical focused school that was the first to bridge the gap between law and economics. Ronald Coase and Gary Becker further expanded beyond antitrust and taxation. Coase is famous for the Coase theorem and the problem of social law cost, which is a very famous paper which states the values resources as that if there is no cost, the one who values resources most will get it. He illustrated it using British common law. But the point is it was very theoretical because in the real world, transaction costs are never zero. So, but despite being an economist, he joined the law school and caused the formation of the fields of property rights economics and transaction costs economics into the law school. And his article became canonical and the most cited law review article of all time. It should be noted, just for anyone from University of Virginia, that Coase did actually write the article when he was at the University of Virginia, but Ron Harris considers him a University of Chicago individual. But just if anyone from the University of Virginia is listening, then that's something to note. Becker in 1955, who wrote his doctoral dissertation in 1955, but it was published in 1957, extended the realm of neoclassical theory to non-market settings, starting from racial discrimination to family to crime and punishment in the late 1960s. And what he really brought to the field of law and from an economic standpoint was that criminals are rational, and therefore he advocating for reducing enforcement expenditures and increasing harsher sanctions. And this was much criticized by lawyers at the time, but what he was doing here was bringing an economics component into the law schools. and then he joined the University of Chicago in 1968. And he was still at the time more interested in economics than law, and it was later, as Harris notes, advocates, Posner who really set the research agenda. But the point that Mar is really emphasizing, or pardon me, Harris is emphasizing, is that all these people sort of gravitated to the University of Chicago, which was a very conservative school, which was combining the law and economics. Guido Calabresi, who was an untenured professor at Yale Law School, wrote Some Thoughts on Risk Distribution and the Law of Torts in 1961 and the Costs of Accidents in 1970, which discussed the costs of activities borne in punishment, and there was no affiliation, and he discovered this independent of both Coase and Becker, and he was inspired much by welfare economics. But the point was that that Harris is noting here is that an individual at Yale Law School, Calabresi, independently started merging economics and law. So although Harris does advocate that a lot of this did originate in Chicago, particularly the University of Chicago, there were some independent individuals as well, such as Calabresi. So then moving to the Chicago formative period in 1970 to 1985. So as he noted, it was Becker, for example, was not as interested in law, and it was really Posner who brought it. So Chicago law and economics became dominant within the law and economics for its intellectual persuasiveness, and it included contingencies and personal institutional factors. So contingencies, as Del Mar notes, are so important. But Roger Posner, eventually, who graduated from Harvard Law School in 1962 and clerked for Supreme Court Justice Brennan and worked for Federal Trade Commission and Solicitor General Thurgood Marshall, in 1968 found a teaching position at Stanford Law School. However, there he met Stigler and Director and followed them to University of Chicago. So once again, gravitating to this really technical school that was at the time combining both law and economics. And given his background, he had spent time in the Treasury and had much experience in that, but also, unlike the other economists who had been merging economics and law, he had a really strict law background and very strong law background as well too. He had a distinct, he was distinct as an because he was not an economist, and he wrote the Economic Analysis of Law in 1973, which moved beyond Director and Levy's taxation and antitrust specific rules. He had a normative criteria, which was that one should seek wealth maximization. It's different from the Calder-Hicks superior. Well, he advocates that Calder-Hicks is superior to the Pareto superior. So Pareto is that essentially he advocates for greater wealth generally rather than Pareto would be for the next individual or for any one. He applied price theory to torts, contracts, and property law, and then further expanded into criminal law, constitutional law, regulation, legal processes, family law, and he started the Journal of Legal Studies in 1970, and in the 1980s and the 1970s and the 1980s became a heyday for debate between law and economics. But the point was here that the Journal of Legal Studies, which he founded, although titled the Journal of Legal Studies, had a really economics focus. So it's what Harris is proving here is that economics is really starting to find its influence in law. And then further, the next section that Harris moves to is the expansion beyond Chicago. So Henry Mann from Chicago became dean, who later became dean of George Mason School of Law, wrote The Mergers and Market Control, which is a critical piece in advocating against monopolies and a critical piece in antitrust. And he gave many seminars all over the country, so really started expanding the University of Chicago influence across the United States. And in 1974, he initiated a program for training federal judges in economics and law and economics. So therefore putting an economic influence into the judges as well. He held positions also at 6 other law schools, so had his influence in many different places. And from 1977 to 1983, it was noted that 8 leading PhDs were hired at leading law schools, which probably doesn't sound like that much now, but at this time this was quite significant. In 1986 and 1989, 5 more were hired, but Harris does note that they were predominantly white men, but that was not a regular for the time. Furthermore, there were 4 more law and economics journals were also produced between 1981 and 1999. The 2 big financiers of this law and economics essentially infiltrating the law were the Liberty Fund and the Olin Foundation. Particularly in the latter, the president of the latter, the Olin Foundation, was William Simons, who was the Secretary of the Treasury for Nixon and Ford. And by the end of the century, the Olin program, there were Olin programs at Berkeley, Chicago, University of Chicago, Columbia, Duke, Georgetown, Harvard, University of Pennsylvania, Stanford, University of Toronto, University of Virginia, Yale, Emory, Miami, George Mason, and later in the next decade, Cornell and Michigan. So the Olin Foundation really started getting its influence in all these law schools. And it said it donated $50 million in terms of pushing for neoconservative and its right-wing agenda, which although 50 million might not sound like that much, it was quite significant at the time. But furthermore, for coming from economists, they must have probably known what they were doing with their money, but also believed that it was worthy of the expenditure. Posner and the Chicago, and also from the University of Chicago, Frank Esterbrook, were also appointed to the U.S. Court of Appeals 7th Circuit in 1981 and 1985. So not only was there training for federal judges, but the individuals from the University of Chicago were actually becoming judges. And furthermore, Guido Calabresi, who was independent from Yale, joined the second United States Supreme Court 2nd Circuit, or Court of Appeals 2nd Circuit in 1994. So a lot of these economists were actually getting judicial placements. The large influence of public choice economics, which was influenced by Arrow, Buchanan, Downs, Olson, and others as well, game theory, which was pushed forward by Nash, Selton, and Harsanyi, who won the Nobel Prize in 1994, and Schelling and Oman won in 2005. So a few independent, not independent, but a few economics was starting to become a very, very prominent thing. But what Harris is noting here is that independent of the foundations, there were a lot of discoveries going on in economics that made it such a popular thing at the time. Behavioral economics was also growing too. There was less antitrust and less focus on antitrust and taxation. Furthermore, there was founded the European Law and Economics Association in 1984, the Latin American and Caribbean Foundation in 1995, an Asia Law and Economics Association in 2005, and many other country-level law and economics associations as well. So then Harris moves into the 21st century, he said there were the University of Chicago says 10 papers by the University of Chicago may be sufficient to almost entirely understand the interaction between law and economics. So really driving the University of Chicago has been particularly influential in this. And it must be noted that Harris is not biased toward Chicago, because it's not like he currently teaches at the University of Chicago. So really, I think he's taking an objective approach to this. In 2011 to 2015, 67% of law schools hired, 60% of law school hires had PhDs, 25 to 30% of which were in economics. So really, the influence had grown incredibly from having only 8 in 30 years earlier. So Harris does question, will there be a split again, a divergence between law and economics, but it seems unlikely, especially as it's relevant in fields such as medical malpractice, judicial behavior, and broader decision-making. Board decision-making, like corporate boards. And then he moves to the next section, the ahistorical nature of law and economics. So the difficulty, he notes, is that there's the static state is not burdened by the past. So the economics does not actually care that much about history. It's because economics is supposed to be deterministic, as Posner notes, and Posner notes that the history it's too. Some historians, note that it's too simplistic. However, Posner says that some individuals criticize Posner as being too deterministic, and as well that economics can be too simplistic. Furthermore, some historians say that when economists do use history, they cherry pick examples, or if anything, focus on recent histories, if anything, and ignore the further back history. Also, some historians they've criticized. They say that economics is not as ethical as well because it helps the strong in favor of the weak. But this is not all historians saying this, and this is not all economists saying this. Furthermore, but Harris says that it's a weak start for history in that there's the two, economics and history, may be irreconcilable. So although there is a distinct link between economics and law, as we've seen through the Chicago movement, and law and history, as Maximilian Del Mar noted, is there a link between economics, law, and history? So what are the prospects? So Harris says, I would like to explore the prospects for meaningful future integration into law and economics into 3 areas: the history of capitalism, empirical legal studies, and institutional economics, all of which could benefit through historical studies. For example, the 2007 to 2010 subprime mortgage crisis would be a wake-up call, though. Although you can study the economics, one must also study history by studying it generally. And furthermore, he notes that history of capitalism is a fashionable label that might get some economists interested in it. Furthermore, the American Bar Foundation has organized the Law in History of Capitalism Conference. So perhaps by referring to the history of capitalism, they might be able to attract more economists. But there's still a gap between economics and law and history that just by using the term capitalism or focusing on capitalism, that he is somewhat skeptical if it might be able to be linked. However, I think I'll give my conclusion after this next point. So there are also, he notes 5 genres of typology that he states are areas in which history and economics can combine. And Dan Klarman, a decade later, also noted 5 other genres of typology, or his own 5 genres of typology. But essentially, I think that Harris answers his own question in that by his study of the history of economics, starting from the Chicago School, he did, and in this chapter, he does merge law, history, and economics. So although he might be skeptical if how many people support it, I think that individuals like him are achieving the vision that he hopes. So I think he's doing a great job. Good job, Professor Ron Harris. So in terms of the slide we have here, his nationality is Israeli. His position, the Kalman Lebowski Professor of Law and History and former Dean at the Faculty of Law in Tel Aviv University. So his suggested readings, Going the Distance, Eurasian Trade and the Rise of the Business Corporation from 1400 to 1700, Industrializing English Law, Entrepreneurship and Business Organization, 1844 to 1920 to 1944. That's an error. That should be a 19 on the latter date. The History of Law in a Multicultural Society, that should, Israel, 1917 to 1967. The images, we have Tel Aviv University, below it the symbol of the Buchanan Faculty of Law, below that Columbia University, where he received his doctorate, below that the Economic History Association of Israel, which he co-founded. And as we have the quotes here, these are the questions that he hoped to address, and which he did address. How did the law and economics movement, law and economics, become so rapidly influential, as we've seen, because many leading intellectuals? What made law and economics so controversial from the start? As we've seen, it diverged from some of the long-standing beliefs. For example, moving from Pareto optimal to the alternative, which would be wealth maximization, and what are the prospects for future interactions? As I think the answer is that he himself is doing. So, on to the comparison. So in the spirit of Plutarch's Lives and in the other series, the comparison between Maximilian Del Mar and Ron Harris, I think the similarity is, and I don't want to be repetitive when I say this in the future on all the other intellectuals, is that they do have a focus on both law and history. However, where they differ is that Maximilian kind of studies within the field of history itself, whereas Ron Harris seems to study between law and history, between that and other fields. So one is studying within the field and one is studying amongst the fields. Maximilian is focused on the positive and the theoretically generative components of legal history. However, Ron Harris notes that history itself clashes with empiricism, and he generally notes that it is a negative component. I would say Maximilian Del Mar is a bit more of a categorizer. He's categorized many of the intellectuals, for example, and their different ideas or different ways of thinking, whereas Ron Harris proved to be a really great, more of a storyteller, as he sort of just shared the story of the development of law and economics and their merging. They both, however, really noted and really appreciated, or not necessarily appreciated, but did give credit where it's due to many great intellectuals. So many of them mentioned many different names, and I apologize if I covered a lot of names here that you might not be familiar with as well. I had to look up a lot of them myself, and just understanding who all these people are, so these people know a lot of people. And so therefore I think that one of the similarities between them and I think myself as well is that they seem to have quite a people approach. So that is the first two chapters and the intellectual endeavors of Maximilian Del Mar and Ron Harris from the Oxford Handbook of Legal History by Markus D. Dubber and Christopher Tomlins. So thank you so much.